Good morning. Thank you all for coming. This is our 10th annual e-commerce best practices conference. We're delighted to have you here. One of the great parts of this conference is the participants. We have a very exciting high-level audience for the whole presentation. And as most of you know, this is very much an interactive conference. So we don't really want you to be an audience as much as participants in the conference. We've got a full day planned, which leads right up through the General Counsel conference at the end of the day, and the wine and cheese, and I hope you'll be able to stay for all of the sessions. The program is sponsored by Stanford Center for E-Commerce, which is a group of academics and practitioners that try to bring practical solutions to the e-commerce world. We try to bring together the great minds of Stanford and other academic institutions with the practicing lawyers and business people who actually decide what are the best practices. The focus of the conference is very practical, although we'll be talking about a lot of the most important cutting-edge issues in the area of internet law. Our focus really is on best practices. What are companies doing, or what should companies be doing, particularly in areas where the law is unclear or may impose conflicting obligations. We've got a great conference today. We're delighted that you're here, and if you're interested in the center, please get in touch with myself, Professor Lemley, or Roland Vogel. The conference today could not take place without Mark's very active involvement and Roland's very hard work. Roland is Executive Director of the Program of Law, Science, and Technology here at Stanford and has done just a tremendous job, not only this year, but over all 10 years. And we've got a terrific group of people at Stanford who really make this possible each year. So thank you so much. I want to introduce Bill Cosden, because part of the success that we've had over the 10 years has been a partnership between Stanford and the Bay Area American Corporate Counsel Organization, which has really helped keep us focused on very practical, business-oriented solutions. Bill?
Okay. Thank you, Ian and Mark and Stanford. This has been a joyous 10-year relationship with Stanford and this program, and very much want to echo Ian's comments about Roland Vogel and his staff and how great they've been, and we're literally celebrating our 10th birthday. As many of you know, have been here previously, this conference is absolutely rich in its content, in its insights, and the marvelous part about it is that we get to see each other every year and connect, and we strongly encourage you to stay through the day and the wine and cheese, and because the human part about it and the contact, just face-to-face, simple human communication like it was done in the early ages, is just another wonderful component to this conference. So thank you, Mark, Ian, and Roland, and the e-commerce program here at Stanford. Thank you very much, and welcome.
I just want to say welcome, actually, to Stanford. Thank you for braving what I understand to be an even worse than usual commute, and actually making it here at 8:30 in the morning. Yeah.
So let's get started. The first panel is an amazing panel. We're going to be focusing on best practices regarding online resale and retransmission of content. And we have a star-studded all-star cast of some of the best litigators, some of the most important companies, and one of the best known and most respected copyright professors in the country to tackle these issues. So without further ado, I'd like to ask each member of the panel to just spend a minute briefly introducing themselves, and then we'll jump right in. Professor?
Yeah, I'm Paul Goldstein. I have been teaching copyright at Stanford Law School, where I'm on the faculty since 1975. Before I think like half of you were born, and have been of counsel at Morrison & Forster since 1989, dividing my time between counseling clients and on issues of the sort we're going to talk about today, and working on litigation matters.
I'm Joe Gratz. I'm a partner at Durie Tangri in San Francisco. I practice litigation focused on internet issues. Mostly on the tech company side of things. We've had a number of cases that sort of relate to the subject matter of the panel. We were counsel for the retransmission or non-retransmission service Zediva, depending on which side you were on, have done a number of physical first sale cases in the Ninth Circuit. I also practice internet-related patent and privacy litigation and advise on those issues. And sandwiched as I am between two eminent professors, I find it necessary to add, I teach as an adjunct at UC Hastings, as well as my law practice.
I'm Mark Lemley. I am a professor here in the law school and run our program in law science and technology. I am also a partner with Joe at Durie Tangri, where I litigate a variety of both patent and copyright cases. Of relevance to this panel, I am counsel for Dish Network in the Fox case, which is one of the ones we're going to talk about, along with my partner Mike Page in the back and the folks at Orrick Harrington. And Joe and I actually collaborated on an amicus brief in the Kurtzsang case, which we're all going to talk about. So, disclosures as appropriate.
Great. I'm Tom Rubin. I'm Chief Intellectual Property Strategy Counsel at Microsoft. In that capacity, I run the Copyright, Trademark, and Trade Secret group that's responsible for both product development and global policy in those areas. I've been at Microsoft since November of 1998, which was 2 weeks after the enactment of the DMCA. So I've lived the entire history of the DMCA from my perch at Microsoft. And what's particularly relevant in that regard is that Microsoft is both a very substantial copyright owner. The Windows Office and Xbox games like Halo have been fortunate to be some of the most successful copyrighted works ever. And Microsoft is also a very substantial online service provider. And with the migration of even our business model from software to devices and services, the online component of what we and others, do is of particular importance to the future of the company. So we really are on both sides of the issues that we're going to be discussing today, and are actively involved in policy discussions about them. The last thing I'd add, being here at Stanford, first, congratulations on the 10th conference. It's great to mark that occasion. I'm honored to share the panel with everyone here, and particularly Paul, who was my copyright professor 25 years ago here in these halls. I've also had the great pleasure of teaching a seminar here basically on internet and copyright issues, and it's great to be back.
Hi, I'm Tod Cohen, Vice President and Deputy General Counsel for Global Government Relations for eBay. I opened the government relations group for eBay in March 2000. Prior to that, I spent 2 years with the Motion Picture Association of America, and before that, at Covington & Burling as a BSA lawyer, spending 2 years in Europe. So I've been on many sides of these disputes and many sides of the debates. I was fortunate enough to work on the DMCA and many other of the statutes that we all live under today. And from our perches at eBay, we work globally on many of the issues that we're highlighting today, and one of our focuses on is not just how U.S. copyright law impacts and U.S. intellectual property law impacts companies, but really how you deal with it in a globalized world. And we'll talk a little bit about Kurtzsang in a little bit.
I'm Karen Thorland. I'm Senior Vice President, Global Content Protection Counsel at the Motion Picture Association of America. That's the trade organization that represents the 6 major motion picture studios. My job is running or managing litigation here in the U.S., where our member companies litigate together, and also overseeing our global litigation. But another large piece of what I do is advise my own organization as well as our member companies on other types of content protection, which includes outreach directly to the various players in the online ecosystem. One of the things I manage is the hot file litigation, which is a litigation against a cyber locker pending in the Southern District of Florida. Also the ISO Hunt litigation, which is here in California. Prior to joining the MPAA, I was a partner at Loeb & Loeb, where I litigated copyright cases, including one that involved Joe for a while, and represented both studios, record labels, and even internet advertisers. So that's my background.
Hi, my name is Elizabeth Valentina. I'm Vice President, Worldwide Content Protection Litigation for the Fox Entertainment entities, including the Fox Movie Studio, Television Studio, Networks Group, Home Entertainment, and Broadcasting. So as you can imagine, my internal clients are actually plaintiffs in a lot of the cases we're going to be talking about today, including Aereo Killer, Dish. We filed amicus briefs in Kurtzang and other cases involving those issues. We are plaintiff in Hotfile and ISO Hunt. So these issues are very close to me. And prior to joining Fox, I was a litigator at Jenner & Block, also working on these cases.
So as you can see, we have an all-star group to talk about some very interesting and complicated issues. The first issue we wanted to address is online rebroadcasting of over-the-air television and the WNET v. Aereo decision. And to tee up the issue, we've asked Professor Goldstein, the preeminent copyright scholar in the country, to set up the issues for us.
Oh, that's a great setup for me. Thanks, Ian. I'm wondering if I might go over there. Is that,
absolutely.
Is that okay? Just have a better view of all of you. So as Ian indicated, I'm going to say a few words about the law and best practices surrounding the decision of the Second Circuit Court of Appeals in WNET against Aereo, delivered up this April Fool's Day 2013. There were other issues in the case. In fact, the case is now back in the Southern District on a summary judgment motion dealing with those issues. I'm going to focus on the public performance issue, the rebroadcast, if you will, issue that Ian alluded to. And to give you the nub of what that case is about, or the question raised by that case, is, does it constitute a public performance of a copyrighted work, in this case, broadcast television, to perform, to transmit without authority that work from one site to another site, where the transmission is from a copy, a unique copy made at the instance of, in this case, the Aereo subscriber, and is received only by that subscriber and his or her family. So does it constitute public performance to transmit from a single unique copy of a work to a single unique household? To put it in context, and I'll come back to the Aereo decision, to put it in context, from the very beginning, the performance right in copyright has been a public performance right. This is the case not only in the United States, but in every country in the world. For performance an unauthorized performance to infringe, it must be a public performance. When the performance right emerged in the mid-19th century, what is a public performance? The concept was in a theater, in a room like this. This would be a public performance. 20th century, to that is added broadcasting, where the receipt of the transmission will be private in someone's home or living room or TV room, but the transmission is made from a single work to millions of people, or tens or hundreds of thousands of people across the country. The concept of public performance expanded in the 20th century to encompass broadcast. The 21st century presents a unique challenge to the public performance right, and that's what the Aereo case and the surrounding cases are about. Picture the celestial jukebox in which a performance will be made, a transmission will be made from a single copy to a single viewer, and no one else is watching the transmission of that work at that particular time. Can anything be more private than that, some would say? And if those uses went unregulated by copyright, the effect would be to eviscerate the economics of the copyright industries as a whole. since all works, all performances, or the great bulk of them, would be in private places. Congress foresaw that in the 1976 Act, created a definition, an additional definition of public performance, and I'll give it to you because this was the operational phrase both in the Aereo case, the Aereo killer case, the Cablevision case on which they relied, and the on-command case. To transmit a performance, this is public performance, to transmit a performance to the public, whether members of the public capable of receiving the performance receive it in the same place or in separate places and at the same time or at different times, thereby contemplating the use of the celestial jukebox. Now, any formulation like that invites engineering around. How can I create a system that will create not a public performance, but a private performance? The first clear instance of it was here in the, or it came up in litigation here in the Northern District, the on-command litigation. On-command, previously called End Run Productions. They changed their name when they realized it wouldn't play that well in the context of the litigation. On-command designed a system under which in a hotel basement there would be a rack of video cassettes, and any guest at the hotel could play a single video cassette in his or her room. While she was playing the video cassette, no one else could access that particular video cassette. On Command says this is a private performance, not a public performance. Full disclosure, Morrison and Forster represented the motion picture studios in that case, and I worked on the case. Judge Weigel's summary judgment for the motion picture studios. It was a declaratory judgment action on command against Columbia Pictures et al., saying this was a transmission to the public, that is, the people in the hotel rooms were strangers to each other and to the copyright owner, hence it was a public performance. Fast forward 16 years to the Second Circuit, you have another end run attempted, in this case by Cablevision, to get to the nub of the performance part of that case. Remote DVR. A subscriber, a Cablevision subscriber, picks a program to be recorded on its unique corner of a hard drive maintained by Cablevision, so that there will be arguably millions of copies of Dancing with Stars, one allocated to each subscriber. Not cost efficient, but it is a way Cablevision thought around the statute. And then that unique copy is transmitted to the subscriber. Then District Judge Denny Chin said this was an infringement of the public performance right, and he relied in part on the on-command decision from the Ninth Circuit. On appeal, the Second Circuit Court of Appeals reversed, said no, this is a unique transmission. We're not talking about the performance. It's a transmission to only one person at a time, and this falls outside the public performance right, given the fact that there was a single recording allocated to this person. The transmission was to that person alone, no public performance. The next case to come up, and this is the April Fool's decision of the WNET against Aereo. Aereo maintains a vast array of dime-sized antennas, one allocated to each user at a time, each of its subscribers at a time. Subscriber says, I want to watch and or record this particular live broadcast. We're talking typically about local signals of broadcasting. I want to watch and or record it, transmit it to me over, well, in this case, over the internet. That will be just like Cablevision. The district court said this is squarely like Cablevision. The Second Circuit, in its decision, talked a bit more about it, but said, yes, this is like Cablevision as well, and exonerated the use, affirming the district court. There was a vigorous dissent from, guess who? Judge Denny Chin had by then ascended to the Second Circuit, and he wrote a vigorous dissent, relying this time, he was still looking westward, but he wasn't relying on command as he did in his district court decision in Cablevision. Rather, he looked at a decision just a few months earlier, December 27th, 2012, in the Central District of California, the Aereo Killer decision from Judge Wu, in which the court, which involved, as you might gather from the name of the defendant, a technology on all fours with the Aereo technology. There were some modest, not relevant differences. Judge Wu said, relying on command, distinguishing or rejecting Cablevision, this does constitute a public performance. What happened in the Aereo case in the Second Circuit, when it happens here in the Central District, is a public performance and therefore an infringement. So that's a quick overview of the landscape. What are the best practices, considerations around it? Number one, this is not just about cable retransmission. This is not just about broadcast retransmission. This is about everything that is happening in the cloud. If you are in the cloud or if you have clients in the cloud, what I'm talking about here relates directly to streaming practices in the cloud. Just think of a music storage system. You could have a locker system. It could be a dumb locker, it could be a smart locker. Whether it's dumb or smart will affect whether it's a public performance or not in part. But basically the question is whether streaming from the cloud to an individual, one at a time on command, constitutes a public performance or not. Second, as to best practices, although technology clients want to hear that Cablevision is the governing law, that is not the case right now, at least. Cablevision or Aereo, the Aereo case. Aereo originally set up so that its business existed only in the Second Circuit, taking advantage of the contours of the Cablevision decision. They've since announced expansion into the rest of the country, not including, however, the Ninth Circuit, which obviously is a dangerous place for them to do, for Aereo to do business. So what do we have? We have the Aereo case in the Second Circuit. Why is that muddled? There's a petition for rehearing. It was filed just a couple of days after or a couple of weeks after the decision. The Second Circuit hasn't yet decided whether to take the case on rehearing en banc. If it does, I think that will be a signal that an en banc panel will take a different approach. In the Aereo Killer case in the Ninth Circuit, it is on appeal in the Ninth Circuit right now. I think briefing closes sometime in July. No date has yet been set for a hearing here. In the eventuality that there's going to be a circuit split, there's always the possibility of a Supreme Court decision. That eventuality is increased by the fact that there's been a new set of actions filed in the district court in the District of Columbia against Aereo Killer. And so I think things are ripe for a circuit split. This is the kind of case the Supreme Court wants, whether it wants to or not, will look at. At the same time, although there's not that much hope that substantive things will come of it, Congressman Goodlatte is going to have a series of hearings through the end of 2013 on a global copyright revision. They may touch on these issues or not. In any event, hearings will end at the end of this year, and legislation, if there is any, will start and progress through 2014 and 2015. Hence, the best one could advise a client on, if they want to be honest about it and evaluating the risk, is it is a muddle. Whether the end run, the circumvention of public performance that I've described is one that will be sustained nationwide or not is impossible to answer now. And then, although for understandable reasons clients don't like to think about it, there is a whole world out there outside the United States that has taken diverging approaches to these issues. They're not as far along as they are in the U.S., but it seems likely that we will have more developments there, so that global rollouts will need to consider those possibilities as well. Thank you for your attention.
So very quickly, let's have a little discussion on this. If the law is that unclear, what are the best practices, and is the law that unclear? Mark?
Well, so let me just say a couple things about that. So I think we can establish one clear best practice from one of Paul's examples and some others, which is don't name your business for a pirate. If you name your company End Run Productions or Paperback Software or Grokster around Napster, or you're in trouble. Pirate Bay, also probably not a good choice. Then you'll be in trouble. So, I mean, you can look at the law as it's been described in Cablevision and Public Performance and say, well, gosh, it doesn't really make any sense to distinguish between a bunch of individual copies which are then performed only once to one person and a single central copy which is performed to multiple people. So if you're creating all those individual copies, you must be trying to do an end run, as Paul says repeatedly around the law. Although, you know, there's another way to look at that from a technology perspective. I think we sometimes call it obeying the rules. Right? If the copyright law says X is legal and Y is not legal, and you do X, maybe that means you're engaged in an end run around the law and you're violating the spirit of the law, or maybe it means you've actually developed a business model that complies with the law.
Mark, that's just one interpretation of the law currently, and it's not faithful to the actual text of the statute. So I'd be reluctant to advise clients to go with an interpretation that's inconsistent with the statute and the legislative intent of that statute.
Well, but so here's the problem, right? I respectfully disagree with Paul that Congress in 1976 thought about the celestial jukebox. I don't think they had any of this in mind. They had television broadcasting in mind, right?
That's not true. If you'll look at some very interesting legislative history that Judge Weigel cited in his summary judgment opinion in On Command, there is language squarely there in which it's uncanny the extent to which Congress, or whoever wrote the report, Congress contemplated exactly what the celestial jukebox would look like.
And in fact, they contemplated by any device or process. So they contemplated that this could be accomplished by any device or process. And it's also very explicit that you're not to look at just the audience of the physical transmission, the waves going over from me to you. That's not the audience that's being looked at. It's the transmission of the performance. And the statute contemplates that by expressly saying that performance could be received in separate places, separate times, different places, different times.
Right. So the question is, what's a performance, right? And if I transmit once and only once from one source to another source, that's a performance, but it's not a public performance, right? So what the copyright owners have to do to make Cablevision go away is to say, you know what, a bunch of different transmissions from different sources, if they are of the same material, must be aggregated together to create a public performance. Now, that's a possible interpretation of the statute. I don't think it's a correct interpretation of the statute. It is not the interpretation that Cablevision, that Aereo have created, but it's possible to go that direction.
Well, and it is the interpretation that Judge Wu in the Ninth Circuit.
Right. There are not Ninth Circuit. The district court judges have.
We can make it more simple. I'm a cable company, and I'm streaming my content to members of the public at different times at different places by using any device or process. Fits within.
From a single source, you are right. You're from a single source, right? You've got a single source.
Multiple sources. It doesn't matter. There's nothing about unique copies.
It turns out to matter enormously, right? And here's why it matters enormously. If Cablevision is wrong, right? If the fact that different sources transmitting to individual people are public performances, the cloud-based business model cannot exist. right? If you are Dropbox, you are engaged in a public performance when a single private individual comes, puts a material up in the cloud, and then accesses that material themselves. If someone else also has put the same material there, that's now a public performance.
But on your reading, we
Cablevision
can't have
is right,
cable,
if
satellite,
Cablevision
radio,
is right, then you've wiped out
any
the
streaming.
entire celestial jukebox.
All right, I'm getting a kind of stereo effect here.
If you said what happens if Cablevision is wrong, and I understand that. If Cablevision is right, basically you have undermined the entire foundation for on-command performances of the transmissions of the kind we're talking about. See, the problem is, and here I agree with you, Mark, the notion that, well, all they're doing is abiding by the law. One can call it an end run, but they're making these millions of duplicative copies of Dancing with the Stars, and that suffices to avoid the constraints of a public performance definition. Stepping back, as you would, and I think you would agree with me on this, you say, any legal rule, as construed in the Cablevision case, any legal rule that encourages that kind of wasteful conduct, occupying hard drive space with all these duplicative copies, has got a problem with it. And so let's clarify legislatively, I think in this case, although I think that the aerial killer side of it is right and the on-command side is right, let's clarify it so there is no question about this, so that we can have a robust market for on-demand entertainment, and we don't have all of this wasteful duplication going on.
And I think
interestingly,
from a best practices perspective, I think this is actually really important. So I have clients who come to me and say, well, I've read Cablevision, right, and so we're making a bunch of these individual copies, but that's dumb and inefficient. Can't I just send it from a single copy? And the answer,
just get permission.
yeah, right. The answer under the Second Circuit law is no, the law is different each way. Right. So I agree. I agree the law makes no sense. As Jessica Littman put it, it doesn't have to make sense. It just has to be in the statute. If we want to clarify it and make it logically consistent so that an efficient business model can work, I'm in favor of that, although I think Paul and I disagree as to whether that's a model that should require permission from everyone before doing anything in the cloud or not.
Well, even Cablevision hasn't launched the RSDVR because it's just not efficient. They need the copyright owners to come up with a system that actually makes sense and to license it appropriately. And I can't talk about Fox's specific license terms, but I assure you these are not things that content owners would have withheld for extreme amounts of money. It would just have been part of that collaborative process. One more point I want to make is that in Europe, the European Court of Justice considered this issue in the akin law to public performance, communication to the public, and disregarded all of the factors that Cablevision took as significant and basically followed Judge Wu's line. It's a communication to the public. It doesn't matter if there's a copy. It doesn't matter if it's one-to-one. You're streaming to the public. It's a communication to the public.
On Elizabeth's first point, I think that's actually sort of maybe the way of squaring the circle and explaining what in the world was in the minds of the court in Cablevision and otherwise, if they were thinking about the practicalities, which is to say, there's a balance between one cannot run one of these services and do it in the most efficient way and do it in a cost-free way. And the court has sort of imposed through the inefficiency that it requires a cost that is on the same order of magnitude, perhaps, as the cost of licensing. And in doing so, this regime, although it perhaps from a technical or sort of copyright historical perspective doesn't make a ton of sense, tends to, as a practical matter, push service providers toward licensing, although not cut them off and make licensing their only option. Indeed, we've seen this, we saw this, as you saw, Cablevision didn't launch this service. And many of the, many locker services have gotten licenses to be able to do things more efficiently where they could instead, or perhaps at certain points may have instead, relied upon Cablevision. And in that way, sort of the courts, even through their perhaps imperfect reading of the statute, are driving service providers toward a choice where licensing is not sort of obviously the least efficient or obviously the by far the worst economic choice.
Tom,
No,
did you
it
want
certainly
to?
doesn't have to be.
Sorry, did you want to jump in?
Yeah, I am not going to wade into the legal merits of this very great discussion that we're having up here. I just want to talk a little bit, especially given the audience here in the Valley, about sort of the practical business impact of some of this. You know, for Aereo to succeed, it requires at least two things. One is victory in court, and two is victory in the marketplace. And I think that it's worthwhile just thinking about their offering and their price point and what they're actually delivering, and questioning whether ultimately this is actually a value proposition that the consumer is going to want. So I just want to ground some of this in the practical business reality, because I think what we're seeing, but as a result of new technology like Aereo, we're seeing content owners, Fox, others, having to be more flexible in their licensing strategies, and we're seeing distributors and cable companies being more creative in what they are doing. Just this morning, I mean, this is just a data point, just this morning Xbox announced in conjunction with Time Warner Cable that when the Xbox One is launched, Time Warner Cable content, 300 live channels, will be available via the Xbox One. So there's a lot, the point here is there's a lot going on in this space, and I think there's going to be an accelerating amount of deals, content deals, partnerships, and innovation going on in this space. And the ultimate solutions and the ultimate winners are not necessarily going to come out of the Aereos, but they do provide, they are vitally important to follow, and in large part because of the, not even necessarily because of the impact on the Aereo servers, but because of the precedent that they're setting for online lockers more generally and streaming from and access to content in the cloud.
Let's turn to the next issue, which also involves television and efforts to try to get free over-the-air content. In this case, ad skipping technologies, which directly undermines the financial model of free television, which in many ways is similar to a lot of internet content. Elizabeth, do you want to set up that issue?
Sure, and just sort of following on what we were just talking about, one of the big harms in this space is that these third-party services are competing with services that content owners are already offering in collaboration with various different distributors in a legitimate way, with license and other negotiated arrangements. In the online space, in the a la carte space, subscription online, delivery to mobile devices, overnight, 24-hour type access, all sorts of different a la carte models. Ultraviolet, where you can have 12 different account holders and that kind of thing. So along comes Dish, and they want to start doing more than their contract provides. And I'm not going to discuss the contract provisions. I've got to be very careful here. We have all sorts of protective orders in place. But just at a high level, what they're doing is they're offering a service called Primetime Anytime. This service copies all of the network programming during prime time for 8 days and holds it for 8 days. The subscriber only has to click once, say yes, and they will have this entire library of programming available to them that Dish selected, Dish set up. It's their systems making it all happen. They decide how long it stays. They really sort of have all that type of control. And that's called the Primetime Anytime service. And along with Primetime Anytime, there's the Dish Hopper service. This allows this content, this primetime content, to be played back without commercials. Clearly, commercials are a big revenue source for the broadcasters and ultimately the content creators and distributors. So this is harmful to the business. And these kinds of rights, like how many copies you can have for how long on your DVRs, all of that is negotiated between an MVPD, like a cable or satellite company, and the broadcasters. So Dish was really sort of trying to push the envelope here and try to do more than what may have been negotiated in the contract. This is phase one. This goes to a preliminary injunction, which is denied. Judge G saw that the Primetime Anytime service as being initiated by the user and therefore determined that it was the user making the copy. Sort of following the volitional conduct standards set out at Cablevision. We have seen that being rolled back a little bit in a recent case called Redigi, which I'm not sure we might have a chance to discuss, where there was an opening in Cablevision that said if you had enough sort of active participation in the conduct that there might be a role where the cable company would have had the volitional conduct but just didn't find it on those facts. But on other facts you might. And in Redigi, where there's a service that set up the distribution of copyrighted music, the court found sufficient volitional conduct. So here, Judge G did not find sufficient volitional conduct, although she did say that Dish's participation seemed to account for actually more or greater participation than actually in Cablevision. But because she found it was the user, she determined that all of that librarying and copying was basically just time shifting and created a new category for fair use without actually analyzing all the fair use factors and doing the full analysis. And furthermore, the copies that were made in order to create the ad skipping copies, she did find that those infringed, but ultimately she determined that there wasn't irreparable harm because these are the kinds of damages that could be compensated financially. So now this is up on appeal. The appeal was heard early June, and we'll see what the Ninth Circuit does with that. In the meantime, Dish has also now introduced two additional functions. One is being able to stream that content, that stored content, to mobile devices. And the other is the transfer app, whereby a copy can actually be saved to your iPad. So, lo and behold, another preliminary injunction has gone down and oral argument has been heard, but we don't have a decision on that yet. So I think that just sort of sets up some of the broader issues. If anyone wants to jump in here, I'm happy to keep talking about it.
All right, I hate to make this the you and me show, but since I am counsel on the other side, let me just say that some of the facts I would characterize rather differently. Dish makes...
And the rhetoric has been persuasive, apparently.
Dish makes a DVR, right? And it makes a DVR that makes it easier than previous generation DVRs to automatically choose to record certain shows, and it makes it easier than previous DVRs to skip commercials. How many people here have a DVR? How many people have set a season pass? I want to watch all of Downton Abbey or something of that nature, right? So that's what Primetime Anytime allows you to do, but it allows you to do it for a variety of, for all the content on a particular channel, right? I can say.
So where's the line? Like we start with a VCR, and anything that's kind of like a VCR, well, we'll just call it time shifting.
Give me a minute to finish a sentence or two here, right? It is right to say that you can. It's now easier to record more content within the primetime area than it has been. You could do exactly the same thing in prior generation DVRs. It took a little more work. So we've made it somewhat easier to do. It is still the user who makes the choice to do it. And interestingly, Fox didn't object to Primetime Anytime when it was launched because the evidence suggests that Primetime Anytime actually enhanced TV viewing. Right? That if I could record all the Fox shows on a Monday night, well, I might actually watch a show that I wouldn't otherwise seen, and it's only there for 8 days, so it's not as though I'm building up a library and replacing a purchase or something of that nature. What got Fox upset was the introduction of easier commercial skipping technology. Right?
Can you mention replay TV?
Well, so there is I think there is a reasonable concern about whether the content owners, if they could rewind history and eliminate the DVR, would be happy to do so. They actually sued Replay TV and drove them into bankruptcy before we had a resolution on the question of whether automated 30-second skipping of commercials was lawful or not. TiVo got large enough that when TiVo started introducing kind of automated hopping, nobody challenged it. Auto hop makes it somewhat easier still to skip commercials for a particular show. You have to opt into it, but if I opt into it, then I get to skip all the commercials for that particular show. Now that, I think, upset the copyright owners. It was a threat to the business model. It's not right to say it was a threat to the free ad-supported TV, because Dish is, of course, a satellite service that pays hundreds of millions of dollars to the content owners for the streaming of this technology. But it definitely threatens the business model. But the interesting thing about it from a copyright perspective is there's essentially no copyright claim against commercial skipping. The copyright owners don't own the rights in the commercials. There's not a copyright in the whole work, including commercials, that's somehow being copied or altered. So there's a copyright case here against people recording TV shows on their DVR that is driven by the business problem of people are skipping commercials too much. And I think that's one of the things that's made this quite complex. So far, the courts have suggested that this is not unlawful. I disagree with the idea that in doing so they've created a new fair use right. That fair use right was created, if at all, in the Sony decision by the Supreme Court in 1984, when they concluded that recording TV shows in your private home was lawful. But I do think it's worth noting how this relates to our prior discussion. One of the things Elizabeth said was, well, just get a license and you're fine. I think one of the things that the Fox v. Dish case suggests is that you cannot count on being able to get a license for the things you want to do, even if the things you want to do seem perfectly reasonable to you, like recording TV shows in the privacy of your own home and skipping ads when you do so.
Well,
and
right, because that's within the purview of the content owner.
Well, so I think that's the right. So that is the disputed question. But it's what's notable is the more things we put within the purview of the content owner, the greater the risk as a technology company that I'm not going to actually get permission from all of the people I need to get permissions to. The lesson from the music cases, I think, is that if you're a technology company and you try to start a business, as many people did, by saying, I'm going to go line up and get all the permissions I need before I launch, you never see the light of day. Because it turns out to be sufficiently complex and we've loaded sufficiently many rights and permissions requirements that it's virtually impossible to get prior approval to do new things in technology. Because content owners are worried about their existing business model and they don't necessarily see the benefits that come from making content available to people on the terms in which they want to
But
work.
are you advising infringe first, pay later?
No, I think the answer is develop your technology within the bounds of the law. But sometimes, right, that's the bounds of the law are going to be tested, and I think that's what we're doing in Aereo and Cablevision. I think it's what we're doing in Fox v. Dish.
Well, I think it's important to also think a little bit about the consumer here, because obviously there's a short-term consumer interest in being able to skip commercials, and I don't think anybody denies that. But I don't agree with Mark that this isn't a threat to free over-the-air programming. You have to keep in mind that under the current model, someone pays additional licensing fees, and certainly Dish is a sophisticated enough company to wade through that licensing process to have the right not to show commercials. And to the extent you don't have the right, the way that the industry is profiting is from viewership of commercials, not the existence of the commercials, not their placement, because they need to be viewed or no one's going to place them. So what my fear is that over time, what we see is a condensing of what the type of programming is available free over the air, how many options you have available to you, whether we get the same breadth of really quality programming that's free, and that's important for a lot of people in this country. Not everyone has Dish, not everyone has an expensive cable system, and we have some great programming on television. So I think we need to think about consumers in the long term, not just in the short term, skipping a commercial.
I think that's a very interesting point. Professor Goldstein, can you wrap up this segment with a final thought?
Yeah, just a point about best practice that I think this colloquy really tees up nicely, and that is in thinking about whether to introduce a new technology that occupies a space that is, loaded with litigation. One has to watch what practice is like, what people are doing. If you look at, I think Judge Fisher's observation in one question was, well, I make all these copies of Masterpiece Theater. I'll take a whole season of Masterpiece Theater. I'll take a whole season of Jon Stewart and make copies of that. That's perfectly okay. That's my starting point. Well, if he had said that in 1984, when the Supreme Court in Sony and Betamax said, one of the things you can't do and have called fair use is librarying. And basically, he was librarying. Well, between 1984 and today, there's been an evolution of practice among users, among consumers, toward more and more use. And I think Mark outlined what happened, particularly with the dish services. And courts are going to catch up with that. The definition of fair use, in part, is informed by what practice is, what custom is among users. So that to think you can apply Sony and Betamax concept of fair use to technologies today is entirely a mistake. What one needs to do is try to figure out what a court would do, taking Betamax as the springboard, but also taking into account all of the expanded non-permitted but non-litigated against uses made by consumers. At the same time, copyright owners are saying, well, when do we sue? If we bring an action now, we may lose, and that's going to set us back even farther than we were. It becomes a very, very poignant kind of decision to make. And I think that this discussion really highlights what it's about. I know I'd worked on behalf of Universal in the Betamax case, and we were going nuts because at the time that the Universal filed the action, there were a couple of hundred VCRs out there in the world. And the prospect of shutting those uses down was not particularly consequential. The Ninth Circuit was taking a long time with appeals those days, and every day that went by, another few thousand VCRs were sold, so that by the time it got to the Supreme Court, the concern was, will the Supreme Court shut down the copying activities of hundreds of thousands of Americans? It was the same kind of issue that we see here.
That's a very interesting perspective. Turning to other issues beyond the fascinating television issues that we've talked about, cyber lockers, resale of copyrighted works, and selling of virtual goods. Let's start with cyber lockers, which is a broad term that seems to encompass everything from legitimate storage services like Dropbox to Mega Upload, which was seized by the U.S. government and characterized as the largest copyright conspiracy in the history of the world. Very broad term. I'd like to ask Karen Thorland and then Tom Rubin if you could set up this issue and from a practical perspective, what are cyber lockers and what are the good practices?
Sure. And I think it is a very broad term. And I think if you think about the term locker and what that really means, we should be talking about storage. But the reality is that there are a number of businesses out there that aren't really about storage at all. So I think there's a distinction to be made between what is, in my mind, an illegal cyber locker and a company like Dropbox. And one of the ways you need to think about these companies is what are they really emphasizing? What is their business model? Is their business model really about storage, or is it really about something else? And obviously, we don't have a bunch of legal decisions at this stage to point to on cyber lockers. Obviously, the Mega Upload case is not moving forward yet, since there's still the extradition issues. And although we do have a case in Florida, no one gets to hotly debate me on any decisions in that case because we're still waiting for the rulings on the cross motions for summary judgment. But I do have the context of those cases to be able to tell you what I think are the big issues that will be disputed in any dispute related to what's an illegal cyber locker. And I think Tom and I both have a lot of thoughts about what are best practices and things to think about, not only if you're operating a storage business, but also if you're in business, if you're part of the support system for these kinds of services, whether that's because you're a payment processor or you have advertising being placed on these kinds of services, or you're hosting. I think it's an issue for everyone that's involved in that way also of what the courts are likely to focus on. And I think the two big areas are whether or not cyber lockers are liable for inducement of copyright infringement, and then whether or not they stay within the safe harbor. On the inducement front, I mean, I think most people, or a lot of people in this room, have been involved in that issue and have a sense of what that is. But really, the inducement standard has to do with whether the service provider has the object of promoting infringement and fostering infringement. And while we don't have cases on that in the cyber locker front so much in the US, there are other cases that can inform how a court's likely to think about that. And one recent decision is the ISO-Hunt case, which was about a BitTorrent site, but still was about inducement and has some thinking in that decision that I think a court could apply in the context of a cyber locker. And one of the things that the court focused on as being corroborative evidence of inducement was that ISO-Hunt had not taken or considered any steps to try and filter content. And so one of the things I think you need to think about if you are operating a storage service is what steps you can take to look at the content that's actually being stored. And that doesn't necessarily have to be applying a content filter, although that's one option. There are filters that can be employed at the time that content is uploaded to keep copyrighted materials off. It could also be thinking about what files are at high risk to be infringing and maybe taking a closer look at those in some manner. Because one of the phenomenons you see on illegal cyber lockers that I don't think you see as much on another type of storage site is that there will be hundreds of thousands or tens of thousands of links to an identical file and lots of users downloading that file. And I think that's a circumstance where a site should be looking to see what is that file and why is it so popular and why are there so many links to it. And when we think about inducement, I think another issue that's important to think about is what is your payment structure? What's your business model? How are you putting money out? How are you taking money in? Both Mega Upload and Hotfile, which are both obviously litigation targets, had a reward system. So individuals who posted files, especially large files, that were downloaded many times were financially rewarded for that. And they made more money the more people downloaded their files. Is that consistent with a storage site? It doesn't seem to me that it is. And so I think that's something that a court will take a close look at, and I hope they take a close look at in the Hotfile litigation. And another business model for cyber lockers is rewarding people who send people to the site. Their link sends traffic to the site, and then those individuals sign up for what's called a premium account. And a premium account usually allows for faster download of content. And if you're really a site that's about storage, question that be your business model, that people want to get faster downloading of content because, frankly, that's usually motion picture content that people are trying to get. Because if you have a business file that you're sharing with your colleagues or you have a home movie, those aren't necessarily files that are that large or that need to be downloaded that quickly. So when you're looking at legitimate services, what you'll see is paying more for more storage. What you see on a legal cyber locker is that if all you do is store your file, it may actually be deleted. Hotfile, for example, deleted files that had not been accessed in a certain number of days. So their whole business was about getting people to their site, getting memberships, and it wasn't about charging for storage. So I think for best practices, if you're doing business or hosting or providing payment services for a locker site, you might want to look at how they're making their money and think about whether they really are a legitimate storage site. And then the other big issue is obviously the safe harbor. If you show inducement or if you have some evidence of contributory liability, is the site still going to be within the safe harbor? And I think many of you have looked at the requirements of the DMCA and already know these, but they include having a registered DMCA agent. It also requires you to remove and disable infringing material after you have knowledge. And I know Tom probably can talk a little bit more about his views on the knowledge standard and the red flag standard, but I think for cyber lockers, it's also important to think about what it means to remove and disable access, and I'll come back to that. And then you also need to have a policy for the termination of repeat infringers. And I think this is one of the areas where you really see who the legitimate players are, who the storage sites are, and who the illegal cyber lockers are. With respect to having a registered agent, I think a number of companies have taken the position that that's just a technical requirement and that it's being hyper-technical to say you can't have the protection of the safe harbor if you haven't done that. But the court decisions, at least some recent court decisions, don't seem to go that way. There's a case, it's a Perfect 10 case, surprise, surprise, Yandex in the Northern District of California that earlier this summer, the court actually found that it's not being hyper-technical to require a site to have actually registered a DMCA agent, that's a predicate to the safe harbor. So if we're talking about best practices, I know it's a minor issue and hopefully everybody's done it, but be sure that if you are a service provider, you have registered your agent with the Copyright Office. And then turning back to this whole issue of the removal of content and disabling, one of the phenomenons of a cyber locker, again, is that you have thousands of links that often point to a single file, and that's because the cyber locker itself does something called deduplicate. They decide, well, this is an identical file. I can tell that because the hash value is exactly the same. I don't need to store it 4,500 times. I'm just going to store it once on my server and let all of these different links point to it. So what a lot of cyber lockers do is if you send a takedown notice, all they do is disable that link and make it so that link doesn't get you to the content. But the file remains. And I think there's an issue with whether that really complies. It's at least arguable whether that really complies with what the DMCA was meant to do, because the content is still there, and if you have a rights holder telling you that nobody has the right to make this content available for free through an unprotected cyber locker, that should apply to everybody else who put that content into the cloud. And what we actually see on a number of cyber lockers is they'll have something called a link checker. So if I'm somebody that's out there promoting links to my content because I want to get more money from the cyber locker for people coming to it, I can actually, in an automated process, check that my link is still working, that it wasn't taken down by a copyright owner. And if it's not working, then I'll generate a new link and I'll distribute that on my through my linking site or otherwise. So I think that's an important issue. And then just the final thing I want to mention before I give this over to Tom is on the knowledge front, the idea of encryption and how that plays into whether or not you have knowledge of infringing content. As some people may know, during this extradition process, Kim.com has been allowed by the New Zealand courts to start a new business. And he has a new business which is called Mega. And Mega encrypts the files. And Kim.com's position and his lawyer's position is that this protects him from any copyright liability. And he takes the position that it's your data, it's your business, and it's very praisable sort of a privacy-related line, but it isn't really what it's about. I mean, I think you need to keep in mind, technically the way the mega site works is the key to unencrypt the file is actually in the URL that the users generate and then distribute freely on the internet. So this whole idea that the file is encrypted is kind of a joke, because anyone can see the key to unencrypt right there. And we've been talking about a lot of business models that are sort of, in a way, gimmicky and don't make a lot of sense from a technological perspective, and I think this is one. But I also think it doesn't necessarily provide Kim.com and his business partners with any protection under the law, at least under the US law. Given the decision of the court in Amster, the Amster court specifically looked at this issue of encryption and specifically held that encryption can just be willful blindness. And willful blindness under copyright law means that you actually will be deemed to have knowledge in many cases. And the court said in Amster that one who, knowing or strongly suspecting that he's involved in shady dealings, takes steps to make sure that he does not acquire full or exact knowledge of the nature and extent of those dealings is held to have criminal intent. And I think Kim.com and his lawyers should be thinking about that, and I think all of you should, to the extent that you think simply creating encryption and then allowing people to send lots of people to their content with an encryption key really protects you from liability there. And I have more thoughts on best practices for cyber lockers, but I want to give Tom some time.
Great. Thanks a lot for that great and comprehensive overview, Karen. I guess I want to try to keep us on schedule because I know we have some other topics. So I'll talk quickly and briefly and really at more of a macro level. What I said at the beginning when I introduced myself was that I've been at Microsoft during the entire history of the DMCA. And so if you think about, and as I sort of step back and think about the history of cases and the arc of application of 512, I personally think it's fair to say that right now online service, this is the high watermark for online service providers in the history of the DMCA. I think that if you look at the direction the cases have gone, and I think that probably relevant to the folks in this room who are, whose businesses are not geared to promoting infringement, I think that online services are better protected now than they've ever been and have sort of less overhead that they need or less uncertainty, I should say, than they've had since the law was enacted. There are still lots of issues at the margins that are being litigated and are going to be dealt with that I think deal more with more questionable sites and practices, and Karen outlined some, and there are open questions about red flags and willful blindness and inducement, but for the most part, services that are not intending to or not dedicated to, devoted to infringement, and that have robust notice and takedown practices are actually in a better position now than they've ever been in the history of the DMCA. So I think that is a very strong positive for online service providers, but I think it's also important to realize that the high watermark for online service providers does not have to mean it's a low watermark for content owners. A lot of things in life and in business are zero-sum games. I do not believe that this is one of them. Microsoft has a very, very substantial infringement issue that we have to deal with online. We have a devoted team that deals with takedowns of infringing copies of Windows Office, Xbox games like Halo, and et cetera. And that is more than a full-time endeavor. But what we have found is that with the right resources dedicated to it and the right strategy employed in sending takedown notices and the right targets, right targeted efforts, it's actually possible to get the online infringement issue under control. That is, saying a lot, but it's because we have devoted sort of a lot of attention and a lot of focus on how to be most effective in taking down infringing content, that we feel like we have reached that point. And let me just give you an example of the kinds of things that we do as a content owner in order to achieve what we think is sort of a good outcome online, because so in a sense these are almost content owner best practices, but they're worth keeping in mind. I mean, one very simple issue is sort of looking at the scope of the problem. The way we look at it, the issue isn't how many infringements are on the internet or how many notices that we've sent down how many takedown notices we've sent. That's not the metric. There's a very simple metric that we employ to evaluate how effective our takedown is, and that is how long does it take the average user to find infringing content. And if we look at the problem that way, and if we target our takedowns to address that issue, and to increase that time, we think that is the best and most effective way of addressing the problem. And in fact, by being targeted in our takedowns and by employing this metric, we have been able to reach a point where on average, it takes several minutes for the average typical user, who's really who you're seeking to address in this situation, but it takes several minutes for the average user to find infringing content. And we have worked closely with online, as a content owner, we are of course a very large online service provider and have our own DMCA process on the inbound side. On the outbound side, we've worked very closely with a variety of online service providers, also to streamline the sending of notices and the takedown of content. Last year on this panel, I think it was right after Google released its transparency report, I think Fred von Lohman was on the panel, and we talked about the fact that it was a bit of a surprise that Microsoft actually, I think, was number two or three in terms of numbers of takedowns that we sent early on in the transparency report. I think we're lower than that now. But the fact is that if by sending hundreds of thousands of takedown notices that are proper, that are not misdirected, that have been vetted and are directed at infringing content, if sending those notices at that scale is what it takes to address the problem, then that is a really good practice to employ. Fortunately, because of tools that exist now, this is not a manual process, so that these takedown programs can be done at scale and can be effective.
To close out this segment, I would just also note that if you actually look at inducement cases, and there's really only about a half dozen where liability has been imposed, in every case you had defendants that number one, took steps to actively encourage infringement, and number two, did not take simple measures to deter infringement. And what we're seeing, I think, a lot in case law under the DMCA is that companies that maybe don't actively encourage infringement, but stick their head in the stand and ignore what's going on in their service, face greater risk. And I would say from a best practices standpoint, it's probably not enough to not encourage infringement. You really need to take whatever measures, whatever simple measures are available to deter infringement, again, from a best practices standpoint. Let's turn to another very important issue, resale of copyrighted works. The Supreme Court, in between other important issues this year, weighed in on first sale, and that has very significant implications. Todd?
So, for those who know me, this is the longest I've ever remained silent on a panel. So I'm quite proud
I was going to
of
say
today.
that.
And I did want to step back for a moment and think about this and the issues that have been presented today from a perspective of rights holders, and using the term very specifically, versus content owners, because that has a very specific meaning as to the ownership of the goods and services that people purchase, and whether there are rights in which they can have, and as consumers, they have rights post their purchase of those goods and services. And so for our point of view, from the eBay point of view, we were deeply engaged in the Wiley versus Kurtzsang case because one of our sellers, a guy named Mr. Kurtzsang, a doctoral student here in the United States, who was selling textbooks that he and his family and friends purchased for him in Thailand, would then ship them to the United States and then sell them on our platform and resell them to people in the United States. The John S. Wiley Company, John Wiley and Sons Company, sued him for copyright infringement. He lost at the district court level and lost at the appellate court level, and was told that he had to pay approximately, I think the final total was $800,000 for the resale of these books that were authentic. There was no question that, and in all of these instances, we do believe that it is very important as practitioners that it really comes down to authenticity is unbelievably important, and what are the long-term and downstream rights that people have for the goods and services that they purchase. And how you think about that really helps to determine, in many instances, whether the services that you may be providing are legal or illegal. And it goes to the inducement issue that Karen and Tom raised, but it also goes to what are the expectations and the long-term expectations, especially as we move from a goods and hard goods world to a digital world, and whether those rights should extend for alienation of property to a digital world than just in a physical goods world. So for Mr. Kurtzang, the Supreme Court ruled that he had a legal right to resell the books, that under the first sale doctrine, that the rights holder could not prohibit the goods being sold here in the United States, and in a 6-3 decision they put into place. And there's a long history of whether it was originally manufactured outside of the United States or was manufactured in the United States, and when the first sale doctrine would attach. But the bottom line and the court ruled, is that if somebody purchases an authentic good, wherever they purchase that good anywhere in the world, they can resell that good in the United States. And we think that is a great result, because it does not just meet consumers' expectations, it also should meet the expectations of all the rights owners and rights holders and their ability to be able to make a sale and then not restrict further downstream uses of those goods and services. It does have a huge impact as we move to a digital world. And in the digital world, it becomes a question, at least in the United States under US law, as to whether the original copy is what is being sold. Now, Europe, at least somewhat in the Usoft versus Oracle case, did not focus on the reproduction right, and therefore whether an additional copy was made. So in Usoft was selling, Oracle would sell people software licenses, and then Usoft would allow them to resell those same licenses, and then Oracle, of course, sued, and the European Court of Justice ruled that Oracle lost because Usoft had the right, under the distribution right, to allow the resale of that copy, even though it wasn't the identical copy. So the question that is for practitioners really comes down to what is the underlying service and whether it's an authentic good or service that's being sold. And I think the long-term goal in many instances should be an elimination of the world of only licensing, and that we really do have an interest in having an ownership world for consumers to be able to, even in the digital space, resell their goods and services.
Yeah, and to Todd's point, this for those of you who are not copyright aficionados, under copyright law there are different rights, including distribution, including reproduction. As Professor Lemley wrote in an article back in the 1990s, all of those different rights can merge into one when you're dealing on the internet, because the same act of distribution potentially could also be a reproduction, or it could be a public performance, or it could be a public display. And so while Tod outlined how the Supreme Court decision is terrific for creating new markets for resale when you're dealing with hard goods, when you're dealing with digital goods, distribution might simultaneously be a reproduction and there wouldn't be a first sale right. And that's part of the problem. Joe, do you want to address that?
Yeah, I mean, this is the sort of fundamental question. We're almost, I think, at a crossroads between two paths. And I think one of the paths is more obvious and the other is certainly more potentially fraught from a historical copyright law perspective. I think we're at the crossroads and need to choose a path between sort of vindicating consumer expectations about what they're getting when they buy something, whether they're getting something fundamentally different when they buy a CD from Amazon and click the button that says mail it to me, or whether they click on the same web page the button that says, you know, I'd like to download the MP3s, whether they're buying the same thing and should have the same expectations about what they can do with it when they're done, or whether they're doing something totally different, and those are different kinds of transactions, and from a copyright law perspective, we need to treat them differently. And those two things are, I think, in substantial tension right now, although there may be ways that the tension can be relieved. There was mention made earlier today of a business called Redigi that recently lost a summary judgment ruling, at least on part of their case, in the Southern District of New York, and their business model was to, I guess, and is, for people who have bought songs on iTunes to be able to transfer those songs to someone else, get paid for the copy, and the system automatically ensures that when the copy is made at the recipient, the sender no longer has a copy. It's simulating in the digital world exactly what happens when you hand a CD to someone in a used CD store. And the court said, well, no, you don't understand, you see. There's this thing called a copy, and the Copyright Act says a copy is a material object in which a copyrighted work is fixed. And there's this thing called reproduction, and reproduction is causing a material object to be a copy when it wasn't previously a copy. And by moving it from one computer to the other, well, you're not transferring it, you're not distributing it like you would be if you moved a physical object. You are instead making a new copy, and it doesn't matter that one copy was destroyed as part of the same transaction and the number of copies in the world stayed the same. So I think one question is going to be whether our conception in copyright law of reproduction and of what it means to reproduce a work in copies versus merely distributing an extant copy, whether that, either legislatively or in the courts, will in some way yield to consumer expectations about what they can do with their software, as Tod mentioned, as it has in Europe.
I'm going to invoke moderator's privilege to extend the panel slightly into our break. I know we all want a good break, but we've got 20 minutes. But these issues are too important, and so I want to run to 10:05 and limit our break to just 15 minutes. Elizabeth, do you have any comments that you want to make on this issue?
Well, a couple of things I just want to mention about the Kurtzang case is that if what we're saying is you can buy your DVDs in Thailand for much less than you buy them anywhere else, then you're saying the content owner can only sell them in Thailand at that price and not sell them anywhere else because they'll be undercut in all other markets, disrupting exclusive distribution deals by territory and so on. Consumers will be dissatisfied. Our trademarks will be disparaged because they're not going to get the product that they wanted. It'll be materially different. It may not even play in your DVD player. It might have a different region code, might not have an English track, might not have the bonus features that you want. So I think that although the court bought the rhetoric of the parade of horribles that have never actually come to pass in the last 30 years that the law was what it was, this has created a bit of a mess. It's uprooted the importation statute, which was intended to cover off unlawful importation of both legitimate and pirated goods. So some more work is going to need to be done there. On the digital side, digital offerings, especially in the audiovisual world, are often governed by licenses. It's sort of an a la carte, pay for what you eat. Do you want to have it accessible for one night? Do you want to have your whole family be able to access it? So you get an ultraviolet version with it in the cloud. Do you want a subscription where you can get whatever that particular Netflix has available or has those indie documentaries? Or do you want Amazon on demand and you can download it and save it somewhere and have it for later use? Now, these are all sort of governed by licensing relationships, and that just doesn't fit with the first sale model. If there's going to be some sort of transfer, it would have to be a transfer of a license, and that just has to be worked into the contract terms.
And so this is, I think, an interesting point. I mean, so I think Joe's right that we're at a sort of crossroads in a policy sense. But here the point I made earlier that it doesn't have to make sense, it just has to be in the statute, now turns out to help the copyright owners rather than the content industries, right? As the statute is currently written, right, it is the making of a new copy to generate this thing, whether or not the business model is designed to reach this result or not.
Maybe.
Yeah, all right. Maybe we disagree on that. Although I mean, I think it seems to me it's a reproduction, right? And the license point, I think, turns out to be a really interesting one, because what we have done in the digital world is to take an assumption that everything is licensed and not sold, to put them out there in the world subject to contract agreements, which are sometimes negotiated contract agreements between big companies, right? Fox and Dish have a disagreement as to what their contract says, but quite often they are the Apple iTunes license that changes every week, and you click I accept without reading it because it's 50 pages long and it changes every week. If we think that sort of defines the terms of what people can do with their with the content they get, one possibility is that we get this sort of interesting variation in ownership rights and business models. But I think the one thing we haven't seen in the digital world is what Joe points out that a bunch of consumers actually want, which is, I want something in the digital world that looks like the bundle of rights that I could get in the physical world.
But you can still buy a DVD.
I'm sorry?
You could still buy a Blu-ray disc.
In a physical world.
And
that's
then
right.
sell it.
And I think, but although I think if you could treat books or physical objects like we've treated software downloads, my guess is you wouldn't have that set of rights with your DVD. You wouldn't have that set of rights with your book. You'd have a contingent right to a book that said, well, don't sell this, and if you give it to a library, then the library can only use it for 6 months or who knows what, right? We've enabled the creation of that set of limitations in the license world, and that has some benefits. It allows us to kind of structure different transactions and charge different prices for them. But I think what it's turned out to do is to take away something fundamental in the minds of consumers, right, who feel like what I want is some sort of object permanence, right? What I want is sort of to be able to have this thing and not have it go away in 48 hours or suddenly disappear because my computer died and I had to buy a new one and now I have too many computers to be authorized or something of that nature. And I think under current law, that's where we are, and I think but Joe's issue is maybe that's not where we should be.
Paul?
Yeah, just a very brief observation. Listening to the presentation Kurt's saying and then Joe's discussion of the redigi dilemma right now, the culprit of this all are not copyright owners or copyright users. The culprit today is the United States Congress. These are issues that need to be resolved at a congressional level. For courts to try, as they did, let's say, in Cablevision and Ariel Keller, in the redigi case, in the Kurtzang case, to square the situation with contemporary market realities in light of the law they're supposed to be applying is just become totally impossible. The situation today is tenfold more complex than it was in 1965 when effectively Congress started the revision that led to the 1976 Act. That the redigi case, particularly, and both as Joe and Mark described it, is a correct result as a matter of interpretation of the statute, but the statute makes no sense as applied to that set of phenomena. I mentioned the hearings that Congressman Goodlatte has initiated. It's wonderful that he has this as an object. I hold out little hope that there is going to be substantive change, but that doesn't mean we shouldn't observe where the blame lies for the contemporary situation.
Todd, a final thought?
Yeah, just two quick things. Notwithstanding Congress and its ability to move pieces of legislation, keep an eye on the Satellite Home Viewers Act has to be reauthorized in 2014, otherwise Dish TV and DirecTV get turned off. So there will be a must-pass piece of legislation that will touch on copyright in 2014. And the other area which you all should keep a very close eye on is the USTR's position in the Trans-Pacific Partnership and also in the TTIP negotiations, the Transatlantic Trade and Investment, what's the P for? Whatever it is. The TTIP, the US-Europe negotiations, because the outcome of the Kurtzsang case may well have an impact on how USTR views these issues. So there's a place in which there's going to be a lot of these clashes that will go outside of Congress. But in the end, I do think it comes down to, it's the simple question on your iTunes. When you make the choice to rent a copy, you've made a choice to rent that copy. And then they also give you an option to buy that copy. And what fundamentally matters to consumers and ultimately is, how do you dispose of that? If you're unhappy with it, do you have a way to recoup anything from that? And that is really how this world of licensing will be played out.
So now we turn to actually the most difficult part of the conference, where you have to make very tough choices. And these choices are really very difficult and unpleasant, because the alternatives for the next panels are also phenomenal. Data security, best practices regarding mobile payments and crowdfunding, and current software patent issues, all extremely important, exciting issues.
Are we going to be, as in past years, taping everything and uploading it so that you don't have to split the baby and can catch the content?
We are videotaping. For those of you who are here, you will be able to get this fairly soon. For those in cyberspace who are not here, they will see it at a later time delayed point, because that is the option of the licensor, Stanford in this case. The other panels are across the way at the law school. I want to thank this panel. This is an unbelievable cast of stars and a lot of very, very complicated issues. Thank you so much.